My name is Kristen McMahon, and I have the privilege of serving as the president here at the Robert H. Jackson Center in Jamestown, New York. We envision a world where the universal principles of equality, fairness, and justice prevail. The Jackson Center's program theme this year is Accountability, the Role We Have. And we are focused not only on democracy and democratic institutions around the world, but also on the role that individuals, meaning each one of us, organizations, businesses, and our government entities play in the democratic processes, as well as how that participation needs to be active, whether you believe the country is on the right path or you believe everything needs to change. We all have to more actively participate in our democracy. These thoughts are not new. I feel like I say this every year. Robert H. Jackson wrote and spoke on democracy and accountability during his tenures as United States Solicitor General, Attorney General, and Associate Justice on the Supreme Court, as well as, obviously, his time as the Chief U.S. Prosecutor for the International Military Tribunal at Nuremberg. We hope that all of our programs inspire you to have conversations with your family, friends, and colleagues, and to actively participate in civic life and organizations near you. This year, we are celebrating the 85th anniversary of the federal prosecutor speech, which Robert H. Jackson delivered in the rotunda of the Department of Justice on April 1st of 1940. If you haven't read it, I will encourage you to do so. You can find it on our website. And the crux of this speech, and this may come up during tonight's conversation, really is about the awesome power that federal prosecutors wield and Jackson's guidance on how to wield that judiciously and properly. As I think we're all aware, at any given point in time, about half of our country disagrees with the direction of government at any and all levels, that the government is out of step with what public sentiment is. And I feel in my just over 6 years in this role, there's a particular word that I've gained a new appreciation for. And that word is unprecedented. And by appreciation, honestly, I mean abhorrence. I am a lawyer by training and no longer practicing, so I'll leave myself some wiggle room when I say I would be floored if something were truly unprecedented. The challenge is that history is long and our memories are short. And just because we have not experienced something in our lifetime does not make it unprecedented. There are numerous parallels in history that can help us navigate today, but we may have to go digging for them. And today, we'll explore some of those parallels in our federal government, specifically focused on the Department of Justice and its enforcement of federal laws in the administration of justice. I am delighted to introduce our conversants on this topic, Professors Barbara L. McQuade and John Q. Barrett. Barbara McQuade is a professor from practice at the University of Michigan Law School, and she also obtained her bachelor's and law degrees from the University of Michigan as well. Her interests include criminal law, criminal procedure, national security, data privacy, and civil rights. From 2010 to 2017, Professor McQuade served as the U.S. Attorney for the Eastern District of Michigan. Appointed by President Barack Obama, she was the first woman to serve in her position. Professor McQuade also served as Vice Chair of the Attorney General's Advisory Committee and co-chaired its Terrorism and National Security Subcommittee. As U.S. Attorney, she oversaw cases involving public corruption, terrorism, corporate fraud, theft of trade secrets, civil rights, and healthcare fraud, among many others. She also serves as a legal analyst for NBC News and MSNBC. Her work has appeared in the Washington Post, Foreign Policy, Lawfare, Just Security, and National Public Radio. She's been quoted in the New York Times, Time, Newsweek, Politico, and other publications as well. And she is one of the 4 co-hosts of the Sisters in Law podcast. Before becoming U.S. Attorney, Professor McQuade was an assistant U.S. Attorney in Detroit for 12 years, serving as Deputy Chief of the National Security Unit. Professor McQuade is the author of Attack from Within: How Disinformation is Sabotaging America, a comprehensive explanation of the ways disinformation impacts democracy and practical solutions that can be pursued to strengthen the public, media, and truth-based politics. John Q. Barrett is the Benjamin N. Cardozo Professor of Law at St. John's University School of Law. He teaches constitutional law, criminal procedure, and legal history courses. He is also the Elizabeth S. Lenna Fellow here at the Robert H. Jackson Center. He is a graduate of Georgetown University and Harvard Law School, a former U.S. government lawyer and investigator, and a regular media commentator on law, government, and history topics. Before joining the St. John's faculty, Professor Barrett was counselor to Inspector General Michael R. Bromwich at the U.S. Department of Justice from 1994 to 1995. From 1988 to 1993, he was the associate counsel in the Office of Independent Counsel, Lawrence E. Walsh, Iran-Contra. And from 1986 to 1988, he was a law clerk to Judge Higginbotham Jr. of the United States Court of Appeals for the Third Circuit. In addition to teaching constitutional law, criminal procedure, and legal history courses, including on the Nuremberg trials, Professor Barrett has taught Nuremberg-related courses and summer programs. And Professor Barrett speaks regularly about the U.S. Supreme Court, Justice Robert H. Jackson, Nuremberg, Franklin Delano Roosevelt, and other legal and historical topics. 50 years after Jackson's death, Professor Barrett discovered and then edited Jackson's previously unknown manuscript, That Man, an insider's portrait of Franklin Delano Roosevelt. That Man is a memoir of FDR from Jackson's first meeting him in 1911 through their close working relationship and friendship during the New Deal years and World War II. It is FDR biography, Jackson autobiography, and a showcase of Jackson's renowned writing skills. Professors, the floor is yours.
Jackson is one of my all-time favorite justices, mostly because of his writing, but also because of his moral clarity about positions on cases. I teach a course in national security, and we talk about one of his cases in quite a bit of detail, the Youngstown Steel case, where he talks about executive power, which might be something that is of interest these days. But I love Jamestown. My husband and I travel to the Buffalo area because that's where he's from, frequently from Ann Arbor. And so today I got here a little early and was delighted to visit the Lucy Museum. So thank you for that opportunity. So I'm delighted to be here, John. Thank you.
The Jackson Center stands for many things, but from him and his career, a big part of it is his service in the U.S. Department of Justice. In 1936, he moved over from the Treasury Department, which was his first New Deal job, on nomination by President Roosevelt and confirmation by the Senate, to be an assistant attorney general. And those are, in those days, sort of second level down sector responsibilities in headquarters in Main Justice. For a year, Jackson headed the tax division, and then for the next year, 1937, he moved over and headed the antitrust division. Then in 1938, Roosevelt nominated him, and he was confirmed to what was then the #2 job in the department, Solicitor General. And for the next 2 years, he argued the government's Supreme Court cases, defending the laws of the United States, about 40 cases in a 2+ year period. Then in 1940, he was again nominated, promoted to the top job, and became U.S. Attorney General. So in a relatively short period of time, Robert H. Jackson, Jamestown lawyer for 20 years before he went to Washington, became deeply immersed in and reverent about the U.S. Department of Justice. A kind of capstone experience is the April 1, 1940 speech that Kristen mentioned, that Jackson delivered in the Great Hall. It's called The Federal Prosecutor, and it was to an assembled audience of U.S. attorneys from each federal district around the country. That meant someone from Detroit was part of the audience of U.S. attorneys who Jackson assembled to talk about the right way to do their job. And that's really where I want to begin, with that speech and that job, which at a later point was, of course, Barb McQuade's job as, in the district, that is the Eastern District of Michigan, the chief federal law enforcement official, a United States attorney. So Jackson on being a federal prosecutor, and what is it to be a federal prosecutor?
Yeah, well, first let me talk about that speech. I was an assistant U.S. attorney before I was the U.S. attorney in the Eastern District of Michigan. So 12 years as an assistant and then 8 years as the head of the office. But when you become a federal prosecutor and you go to training at the National Advocacy Center, one of the first things they give you is a copy of the speech, The Federal Prosecutor. And it is something that you read and absorb. Many assistant U.S. attorneys will have a copy of it posted, framed in their offices or outside their door. And I can just picture the delivery of that speech in the Great Hall at the Department of Justice. When I was a U.S. attorney, we would have conferences of U.S. attorneys every year where all the U.S. attorneys from around the country would gather in that room to hear an address by the Attorney General. And I don't know that there's been another speech that has been as enduring as the one that Robert Jackson gave to all of those assembled U.S. attorneys in 1940. But he talks about the importance, something I've taken away from that speech is pursuing crimes and not people. And so if there's evidence that a crime has been committed, then charges should be brought. But you should not go the opposite way of picking people to charge and then finding a crime to tag them with. And that is one of the moral guideposts of being a federal prosecutor. But I love the job of being a federal prosecutor. Our job was to seek justice. And so unlike some other jobs where your job is to maximize the position of your client, and that's fine, that's what lawyers do as advocates, I always thought it was a great luxury, and I felt so privileged to do it, that our job was just to do justice. So sometimes you would get evidence that a crime was committed, and you would pursue it with vigor and take it to a grand jury for an indictment and take it to a trial in hopes of a conviction. But there are other times when you gather evidence and you would look at the case and say, either I don't think the evidence is sufficient to convict, or even though I think the evidence is sufficient, I don't think this is the best use of our scarce federal resources. I don't think this is a case that's in the best interest of justice. I don't think it's a case that matters. And so we would have the luxury of declining to bring cases when we thought it was not an appropriate case. And so it was an incredible opportunity to really serve justice. You know, we always learn that the government wins when justice is served. And it was a great privilege to do that. But Robert Jackson's legacy lives on at the Department of Justice, not only because of that speech, but because of the way he served.
Yeah, I had the experience to work in Main Justice, and one of the things that struck me was as you walk the corridors and visit different components, because Jackson held many different jobs, there's his photograph, or there's his portrait, or there's somebody with framed words from Jackson on the wall, or somebody mentions him in conversation. It's too strong to call him a patron saint or the ghost of DOJ, but there is definitely something in the air of Jackson. A piece of the speech is to remind these U.S. attorneys who don't need the reminder how vast their power is. What happens when the power of the Department of Justice is turned on somebody as a subject of investigation, or a target of investigation, or indicted as the defendant in a criminal case? Could you elaborate on that? Because you had that power to do Department of Justice, U.S. government impact on people's lives. What does that involve?
Yes, well, I think it's something that every prosecutor takes very seriously and understands the awesome power of the work. It entails, oftentimes a tip that a crime has been committed. Sometimes it's very obvious, a bank has been robbed. And the question really is just, who was it who robbed the bank? Those are sort of reactive cases and maybe the simplest cases. The more complex cases are the ones where maybe everybody knows what happened, and the question is whether they did it with criminal intent. Those are more proactive cases. Sometimes you see those in the area of white-collar crime or public corruption or other kinds of things. And there you have to think through the very delicate sensitivities in the case. One is trying to not harm someone's reputation if the case will not ultimately turn into a criminal case. It's for that reason that the Department of Justice traditionally neither confirms nor denies even the existence of an investigation, and they occur in the secrecy of a grand jury room. There are times, one of the most significant cases I worked on in my time as a U.S. attorney was the investigation and prosecution of the former mayor of Detroit. But equally sensitive were a number of cases that we looked at of maybe city council members or other prominent individuals in the community. Some of those cases never made it to fruition, and so we very quietly closed those cases without ever alerting the public that they were under investigation, because if you do not have the evidence to bring a case, then the public should not hear about it, and the person's reputation should not be tainted just because there were allegations that they did something wrong. So I think most prosecutors get the training and are steeped in the tradition of the department of being very careful to use this power in a very responsible way. It is why some of the things I'm seeing in the current Department of Justice I find a little bit troubling when I see sometimes the use of that power in a way that does not feel as responsible as it has always felt to me in that tradition of Robert Jackson and prior administrations.
Is the use of that discretion and that power just a function of who you are at your core? That you had good parents, you were raised with good values, you're a good person, and thus you don't smear people, and is it an entirely discretionary power? Or are there things that are rule books and guidance and constraints on federal prosecutors?
I think it's a combination of both of those things. I mean, one of the things, as a U.S. attorney, you get to hire assistant U.S. attorneys, and I remember one of our appellate chief always said, the best personnel program is to hire good people, because you don't have to worry about motivating them, you don't have to worry about even managing them or disciplining them, because they're going to do good work. So I think part of it is trying to select people who have the background, the experience, the intelligence, the qualifications, and the character to make those good decisions. But that's not all there is. There is quite a lot of guidance that governs the discretion of prosecutors. Since the Watergate era, there has been something called the Principles of Federal Prosecution that are contained in something called the Justice Manual. And it has guidelines about how prosecutors ought to cabin their discretion. So there's a lot of discretion about when a case ought to be brought and local priorities. Some things are more pressing in certain communities than other communities. Where I worked in Detroit, violent crime was a top priority. There are other places, perhaps on the southwest border, where immigration or drug cases are a higher priority. In the Southern District of New York, financial crimes are a big priority. So there is some local discretion, but these principles of federal prosecution give a number of guidelines that prosecutors ought to look at. Number one, will there be a protection of public safety if you bring this crime, this prosecution? That's a factor. What's the deterrent value? Other people are watching, and they're going to see, is this crime one that gets prosecuted or one that doesn't get prosecuted? So you want to think about that. What are the national priorities? During the time I was in office, it was all about national security. Counterterrorism was a big priority of the administration. So there are a number of things you look at in considering bringing charges, but then there are also prohibited bases. So you can never bring a case based on race, based on religion, based on age, based on race, based on gender. Those are things that are prohibited. And a very big one is partisan politics. You should never bring a case based on the political activity or affiliation of the person. And that's one where these days, again, I feel that some of the things we're seeing in the current administration perhaps are not abiding by those very important
We're going to get there.
proceedings.
We'll get there. One more predicate before we make the turn. Could you explain the difference between main justice headquarters and the field structure, U.S. attorneys' offices, and what this whole big footprint of power is?
Yes, so the Attorney General, Robert Jackson was one of them. Our current Attorney General is Pam Bondi, is the head of the U.S. Department of Justice in Washington, D.C., a member of the President's cabinet. And there are a number of functions in Main Justice, a lot of subject matter experts who work there. But then out in the field, as we say, there are 94 judicial districts. Here we are in the Western District of New York. There's a headquarters in Buffalo where a U.S. attorney is appointed by the president to prosecute federal crimes that occur in this part of the country. New York, big state, has 4 judicial districts. Michigan, where I live, medium-sized state, we have 2 judicial districts, the eastern and the western. Some of the states that are less populous will have only 1. You know, the District of Wyoming has 1 district altogether. California has 4. And each of those judicial districts has a U.S. attorney and has a number of assistant U.S. attorneys, again, allocated based on the population and the crime control needs of that community. So where I worked in the Eastern District of Michigan, in Michigan we're fond of using our mitten map. You know, we've got the Lower Peninsula and the Upper Peninsula that we make like this. And if you were to divide the Eastern District of Michigan in half, the Eastern District, or the Lower Peninsula, the Eastern District of Michigan is the eastern half. So Detroit, Ann Arbor, Flint, Pontiac, Saginaw, Ypsilanti, all of these cities are in the eastern. And we had about 115 assistant U.S. attorneys divided, handling things like violent crime, white-collar crime, healthcare fraud, public corruption, drug trafficking, and other crimes that are violations of federal law. We also have a civil division that brings lawsuits on behalf of the United States or defends the United States government when they are sued in court. And so most of the cases percolate up around the country out of these districts. That's where cases are brought because cases occur locally. Sometimes in some of the smaller districts, they might bring in a specialist from Washington. If you're in one of the really teeny tiny districts, like I think southern Iowa has fewer than 20 assistant U.S. attorneys, they might need a specialist to come in from Washington to handle a tax case or an antitrust case or a hate crimes case or something like that. In Detroit, we mostly handle our own cases, but we did from time to time get resources from Washington. Maybe a computer crime specialist might help us on a case. And you know, those components had some review of some of the activities. But one of the things we always thought of is that mostly our work was independent of Main Justice. We certainly would notify the Justice Department if there was a very significant case that was occurring in our district, but mostly we were allowed to choose our own priorities and have discretion in the cases where we brought a case. I never once had an attorney general overrule one of my charging decisions. We charged Democratic politicians, Republican politicians, based on fact and law, corporations, powerful people, and we did it based on fact and law, and I never once had an attorney general push back on a charging decision.
What about the White House? You said the attorney general is in the cabinet. Obviously, the president decides who he wants to be in the cabinet. And it's not very far physically from 1600 Pennsylvania Avenue to Main Justice, and Main Justice is the boss. So what's the White House historical role over the Department of Justice?
So, you know, my experience of history is really the post-Watergate period until 2016. And during that period, there was very strong division between the White House and the Department of Justice in an effort to avoid not only partisan politics, but even the appearance of partisan politics. And so there were procedures set up post-Watergate that continued all the way through at least the first Trump administration, where there were directives from the White House counsel and the Attorney General that there were to be no conversations between the White House and the Department of Justice, except at the highest levels. So the president might say, these are my priorities. For example, during the Obama administration, the mortgage crisis and the financial banking crisis that happened in 2008 was a priority. They wanted us to pursue cases of mortgage fraud or banking fraud during that time. Civil rights was a priority. Computer crimes was a priority during that time. So those were the priorities, but they let us figure out how we wanted to implement those priorities. There was never any input into any specific case or any particular target. There was no approval and no conversation. In fact, there was a memo that forbade us from having any contact with the White House during that time because it was impressed upon us how important it was that we not only be free of any politics, but that we have public confidence that we were deciding cases based on fact and law and not based on any political interests.
Let's pivot to the current moment. The first contemporary topic I'd like to ask you about is White House control or White House messaging with regard to federal law enforcement functions. We've already talked about the Great Hall. The country saw President Trump visit and speak in the Great Hall this spring.
Yeah, that was highly unusual that, number one, the president would visit the Great Hall. I think presidents have visited in the past, but for ceremonial purposes, maybe to swear in an attorney general or attend their retirement ceremony. Here, he gave a policy speech about his priorities. He referred to, my attorney general and my FBI director. And I think he created a visual image that they were all one and that there was not this separation that we have seen before. And so I was deeply disturbed by that speech where President Trump really talked about how he was taking an active role in the work of the Department of Justice. I think many of the things we've seen reflected by Attorney General Pam Bondi and the executive orders that we've seen issued by this president suggest that they are working very closely together. Now, it's really just norms that have caused this separation since the Watergate era in an effort to promote independence and nonpartisanship and public confidence. There's nothing legally that says it must be done that way. And so I think one of the things we've seen by President Trump is an effort to expand executive power and to take control to the maximal level. And so there is nothing legally that prohibits him from directing the Department of Justice to do what he wants them to do. I think that it is, in the long term, going to erode public trust in the Department of Justice as this nonpartisan independent agency. But he is definitely pushing the limits. And we've seen things like, the Bondi memo about the weaponization of law enforcement that flows from an executive order accusing the Biden administration of weaponizing law enforcement and the need to hold people like Special Counsel Jack Smith and New York Attorney General Letitia James and Manhattan District Attorney Alvin Bragg accountable for engaging in lawfare. We have seen Attorney General Pam Bondi demand that prosecutors engage in zealous advocacy on behalf of the Department of Justice. In the past, certainly you're expected to advance good faith legal arguments on behalf of the department, but it ends at good faith. And if there is not a good faith basis for advancing a legal argument, to concede that point as an officer of the court. And so we are seeing a real push, I think, of those boundaries in the current administration.
The staffing in the Department of Justice includes career people and then political appointees who turn over with new administrations who are the leadership. President Trump has populated the top of the Justice Department with political appointees who are his former criminal and civil defense attorneys. Is that unusual? Does that raise concerns?
This is what we call in the law a leading question. One that suggests the answer. Well, this reminds me a little bit of something I saw on social media today where Senator Josh Hawley was berating a progressive law professor saying, isn't it true that President Trump's executive orders have met with more nationwide injunctions than any other president in the history of America? And the answer was, well, yes, but maybe that's because he's the only president who has issued so many lawless executive orders. So I don't know how many presidents in the past have had to hire criminal defense lawyers. So it is unusual to see people this closely aligned with the president. Now, certainly, President John F. Kennedy hired and appointed his brother to be his attorney general. I suppose you can't get much closer than that. But I think in recent years, we have seen more of a distance, right? We had Joe Biden with Merrick Garland. They were not previously acquainted, but Merrick Garland was this revered federal judge, and his goal, I believe, his stated goal was to restore public confidence in the independence of the Department of Justice rather than someone who would be seen as a political operative. Similarly, with President Obama, he had Eric Holder, who was previously a leader in the Department of Justice, someone who worked on his campaign, I think, but I don't think they'd been friends before that. And then Loretta Lynch, who was not someone he previously knew. So,
and I'll add in Bill Clinton and Janet Reno.
Yeah, there you go, right? I mean, not someone he knew, but someone who was a respected state court prosecutor, attorney general, she was the Miami-Dade County prosecutor in Florida. So no, this was not really something that we had seen before. Usually, the only requirement is that it be someone learned in the law. We saw people choose people as attorney general that they thought were sound, respected lawyers who could handle this big job of leading this huge Department of Justice. And it seems that one of the things, my opinion, is that some of the choices that President Trump has made this term, in contrast to his first term, is choosing people more based on their perceived loyalty than their competency to do the job. And so it seems that that is one of the factors that you see across the board with people like, Pete Hegseth at the Department of Defense and RFK Jr. at Health and Human Services, people that he believes will, foster loyalty over competence. But at the, not only the Attorney General level, but right below that level, we've got people like Todd Blanche and Emil Bove, people who, as you say, were lawyers for President Trump, advancing some of these arguments, some of which were successful, some of which were not, but who clearly gained President Trump's confidence that they were smart lawyers who could also serve his interests.
Right. By the way, we should make explicit that DOJ is not just a lawyer department, that it has investigative components, agents, and so forth, because your description reminds me of the FBI and its current leadership. How's that being run?
Again, leading question. As you probably know, the FBI director is a man named Kash Patel. FBI directors have typically, in recent years, been former prosecutors. We had James Comey, we had Christopher Wray, people who had vast experience leading U.S. attorneys' offices, or Chris Wray had been the head of the criminal division at the Department of Justice. Kash Patel was a government lawyer. He worked in the National Security Division, but has also been, I think some would say, an attack dog for President Trump. He wrote a book called Government Gangsters, in which he included a list of people he accused of being part of the so-called deep state, which I'm not really sure what the deep state is, but I think the idea is unelected bureaucrats who push back against Donald Trump. The professional civil service who try to do their jobs professionally and rein in partisan politics when it rears its ugly head within the government. But he named among the people that he accused as being members of the deep state, not only people who are Democrats, but James Comey, William Barr, people that were obstacles to Trump's first administration. He even wrote a children's book called The Plot Against the King, about how, names, very thinly veiled names, accusing people in the government of attacking King Trump. And the wizard named Cash, who saves the day. No coincidence. No coincidence. So he is the director of the FBI. He also has a man named Dan Bongino, who is a former right-wing podcaster, who is the deputy director. And again, that is a position that typically has been someone who's risen through the ranks of the FBI, somebody who understands its DNA and how it operates, and its nonpartisan aspects. When I was an assistant U.S. attorney, I worked very closely with FBI agents. And I know from them that the worst thing you could accuse an FBI agent of is being political in any way, like sucking up to the boss or any of that was really frowned upon. It was, you do the job, you do the work, you keep your head down, and it's all about facts and law, and nobody cares about politics. So the idea that we have these two in charge of the FBI causes me some great concern. I think I have a lot of faith in our courts as a check on abuse of power, but there's so much, we talked about discretion earlier. There is so much power that the prosecutor has and that agents have to make people's lives miserable if they want to, simply by investigating them. So at the FBI, there's something called the Domestic Investigations Operations Guide. And like all things in government, it has an acronym. It's called the DIOG, D-I-O-G, the DIOG. But it has a lot of rules, again, kind of post-Watergate, but also that era in the 60s and the 70s when the FBI was discovered to have abused many of its powers through J. Edgar Hoover as the 50-year leader of the FBI. They were operating a program called COINTELPRO, where during Vietnam protests and the civil rights movements, they were investigating and wiretapping leaders as subversive threats to the national security. So people like Martin Luther King being surveilled. When all of that abuse was discovered, a lot of rules were put into place to try to protect the American people and to protect all of our civil liberties from that kind of abuse. And that's when the DIOG was created. And some of the rules about the DIOG are things like you can't begin even an investigation based solely on someone's First Amendment protected activity. So if someone's protesting or writing letters to the editor or writing op-eds, that cannot be a basis to begin a case. You must have something called factual predication, that is evidence to believe the person is committing a crime or will be committing a crime or some threat to the national security beyond First Amendment protected activity. But that's just policy. And that can be changed with one stroke of the pen, and it can be changed with approval from high levels of the FBI. So I don't think we know yet exactly what's going on inside the FBI, but I do have concerns based on all of the things that Kash Patel and Dan Bongino have said in the past, that they could quite easily use these immense powers of the FBI in ways very different from the ways we've been accustomed to under the DIOG in recent decades.
Well, we don't know yet, but what kinds of risks are we running, given these staffing decisions, personnel politicization, in terms of apolitical, effective law enforcement that we should have, in terms of national security investigative work that we should have? How worried are you?
I'm very worried. I mean, one thing that's very obvious that I'm worried about is just the prioritization of resources to immigration. Now, certainly we have immigration problems in this country. There should be immigration enforcement. But one of the things that we are seeing is the movement of law enforcement resources, not just from ICE, but also from other federal agencies. You know, FBI, DEA, ATF are now focusing resources on immigration. And they're not prioritizing. You know, when I was in the U.S. Attorney's Office in Detroit, I'm sure here in Buffalo, because of your proximity to Canada, you get immigrants from all over the world that come through at our somewhat porous border. But we used our discretion to decide who we would prosecute coming across the border. If people posed a danger to the national security, if they were posing a danger to public safety, if they were committing violent crimes, we would prosecute them criminally. Otherwise, we would let the administrative immigration courts handle their deportation and removal administratively. Because we only had the bandwidth to do about 1,000 cases a year. And if we were doing only immigration cases, that means cases of violent crime, white-collar crime, national security, drug trafficking, all those other cases would not get brought. In the same way with investigative agencies, if the FBI is focusing its efforts on immigration, that means there's not somebody paying attention to threats from Al-Qaeda and other foreign terrorist organizations. There are not people focusing on white-collar crime, public corruption crimes, street crimes, carjacking, arson, armed robberies. And so I worry that it's kind of open season for other kinds of crimes in the name of protecting the country from immigration. Now, maybe, you know, that is where the public wants our immigration resources to go, our law enforcement resources to go. But I don't think people understand when they say, we want to clean up immigration, we want to, you know, remove dangerous immigrants from our country. I don't think they're realizing the trade-off that they're getting there. So that's one worry I have. The other worry I have, of course, is the politicization of law enforcement. And if they're stating openly that they want to go after this so-called weaponization, and they're pardoning people who engaged in the January 6th attack and dismissing all those cases and firing people who worked on those cases, I worry who else might come within the crosshairs you know, whether they really believe that law enforcement was weaponized in the last administration, or they believe they have the cover to do that, that they have the power. And so I worry about how we might be seeing these vast surveillance powers being used, wiretaps, the ability to put up poll cameras, to follow people, to gather people's electronic communications, what you say in text messages, tax records. All of those things can paint a very unflattering portrait of someone. And then one of the things that concerns me is, Ed Martin was this guy who was nominated to be the U.S. attorney in Washington, D.C. He did not get confirmed, but now he's leading the department's weaponization working group. And one of the things that he says that concerns me is he said, even if we don't have the evidence to bring a criminal case against these people, we are going to name and shame them, because that's what it's all about. Now, as I said before, in previous traditions, if you did not have the evidence to bring a case, you kept it quiet and nobody ever knew about it. If instead they're just going to say, did you know so-and-so is having an extramarital affair? Or did you know this person has spent this much money on a vacation house? Or this person is seeing a psychiatrist? Whatever it is, I worry that we're going to see that name and shame. Or even if it's not about the individual, about their family members or other kinds of things, I worry that it could have a really serious chilling effect on people's decisions to seek public office because they don't want to expose their families to that kind of embarrassment.
The Weaponization Task Force is an odd name. The president's executive order refers to anti-weaponization, and maybe this is an unfair analogy, but think about anti-lynching or anti-littering. The anti part is really important. Ed Martin calls it the Weaponization Task Force. He dropped the ante, or Pam Bondi dropped the ante. And so it does almost in its naming suggest the kind of targeting that you're concerned about. He's not the only attempted interim U.S. attorney appointment. He's got a successor in D.C., interim attorney Jeanine Pirro. He's got, or the president has, interim attorney in the District of New Jersey, Alina Habba. You were nominated and confirmed by the Senate. Is interim U.S. attorneys an alternative that is concerning?
Yes. I mean, remember that Donald Trump said in his first term, I love actings. And that's what they are, right? And why does he love actings? Well, because they don't have to be confirmed by the Senate. And so when you nominate someone for confirmation, you have to make sure that they've got the qualifications for the job and that they won't be perceived as some sort of political hitman, right? That they are someone whose judgment is respected and people will have confidence that they're going to make sound judgments in the important decisions they're going to be making. So interim is slightly different than acting. An interim U.S. attorney may serve for only 120 days. That person may then be nominated and confirmed, but if they are not within that 120-day period, then the court gets to nominate someone, and they usually pick somebody who is a senior leader within that office. 20 years, we know, Joe's been coming to court for 20 years. We trust him. He's a sound lawyer. We're going to make him the interim until the president nominates somebody who gets confirmed by the Senate. What we've seen in Washington is Ed Martin gets nominated as it becomes the interim. He does, quite a astonishing job there with some of the things he says, some of his statements, some of his activity, and he, of course... Some of his tweets, right, where he, referred to himself as President Trump's lawyer. He issued this sort of letter-writing campaign called Operation Whirlwind, where he went after, Georgetown Law School for its DEI and its teaching, and politicians for some of their speeches. But he had also represented some of the January 6th defendants. And then when he was U.S. attorney, dismissed the complaints, the cases against those very people, which is a conflict of interest in my view. And so he didn't have the votes to get confirmed. Interestingly, as I said, the normal process would be at the end of that 120 days, if he's not nominated and confirmed for the permanent spot, it would be the court that would replace him. Instead, President Trump is sort of testing the waters here by picking a second interim in Jeanine Pirro. That hasn't been challenged, but it is questionable legally. But he's putting in place some interims, Alina Habba, he's put an interim in some other districts around the country, and I think the expectation is he will probably nominate those people to become the U.S. attorneys. In the past, when there's been this interim period, typically what has happened is the U.S. attorneys either resign or are fired, and their first assistants will be the acting U.S. attorney. Donald Trump apparently doesn't like that because acting U.S. attorneys are typically career people who are nonpartisan. And instead, it seems to me that he wants to have, at least in some of these key districts, to have his own people there. So he installed his own person in Washington, D.C., in New Jersey, where he has properties, and in New York, although that did not go so well for him because he installed an interim there who, of course, pushed back when he attempted to dismiss the criminal charges against Mayor Eric Adams. So that turned out to be a person with integrity.
Right. How is morale in the career ranks? How is the sort of staffing and functionality going in below the political appointees, the people who year by year and decade by decade are the institutional expertise of DOJ?
Well, based on what I know, just from friends who work in not just in Detroit, but in Washington and elsewhere, on a scale of 1 to 10, I would say the morale is at about -10. It's the people who go to work for there are probably a few who are applauding this and think this is great, but I think by and large, the people who join the Justice Department do so because they want to serve the public. They care about justice, and they have served in a nonpartisan workplace for decades. I mean, I came into the department during the Clinton administration. I worked during the Bush 43 administration, the Obama administration, and a smidge of the Trump administration. And I never cared who was at the top. I cared about the work, and the work didn't change. As we said, sometimes the priorities might change a little bit at the margins, but mostly we're prosecuting crimes that were happening in Detroit. And that work didn't change very much. And now suddenly we're seeing things like, moving resources toward immigration, for example. I have some friends who are judges in Detroit who tell me that their dockets are now consumed with immigration cases. And although there's no problem doing immigration cases, it is at the cost of the other kinds of cases they used to see that they thought were more important in terms of public safety and national security and the deterrent value of crime. And so I think for that reason, they had the fork in the road memo where DOJ came in and made a lot of cuts, and I think that had some impact on morale. The fear of probationary employees being fired, they're sort of on again, off again, mired in litigation. Probationary employees are just, I think lawyers are subject to 2 years. When you first join, you don't get the same civil service protections that you get once you've been there for a couple of years, because they want to make sure you're good at your job before they can fire you. So, an effort to just sort of fire all those people just to get the numbers down. And the numbers, I know in many of these offices are very low. So you've got people doing the job of 115 people with a staff of maybe 85 right now. So I think people are feeling not only unappreciated, but also overworked in this moment.
Right. I want to tick off a number of issues, and you can pick and choose among them.
Okay.
Because time may be getting short. Are you concerned about performative arrests and charges? Judge Hannah Dugan in Milwaukee, for instance, or Mayor Ras Baraka in Newark, and Representative McIver in Newark. Are you concerned about non-predicated investigations, just names that come out on Fox News, and thus Jack Smith or Letitia James or the Biden pardons or something is noise in the air, and thus DOJ is charged to investigate it? Are you concerned about things that would have looked like serious matters for a federal investigation in olden days, say the Pete Hegseth Slack communication involving classified military operational information, or information that Attorney General Bondi sold a whole lot of stock right before the president announced his tariffs? Among other things that are going on.
So many things to choose from. I think the thing, the through line of all of those things, I think, is my concern that the public's going to lose confidence in the Department of Justice. And rightly so, right? I mean, I think they are making performative arrests. This arrest of the congresswoman, of the mayor, of the judge. Certainly no one is above the law. And if somebody is interfering with the work of ICE, certainly thoughts should be given to whether it is necessary to bring criminal charges. But I think in every one of those instances, if I were the U.S. attorney, I can't imagine bringing those criminal charges and taking them to trial. I think I might, make a phone call over there. I might ask ICE to talk about how is it we're going to coordinate our arrests. Are we going to be doing them at the courthouse? And maybe ICE ought to have a conversation with the chief judge to figure out whether that's a good idea, and if so, how they're going to go about that. But the idea of arresting someone does strike me as performative, of sending a message to every judge and every member of Congress and every mayor out there, hey, look out, we're the feds, we're coming in, and there is no neutral ground for any of you. And, and also just sort of throwing red meat to the constituency of, owning the libs. And, it's not a way to govern. It's a great way to campaign, to divide people like that. But when you want to move a country forward, you need to have unity. And all of these things, I think, are designed to create division in society. And then the passes on things like Pete Hegseth and Pam Bondi and the idea that there's not going to be any investigation there. I think the public will rightfully be very skeptical of the Department of Justice. And I worry that it's not going to end with this administration, but it's going to last forevermore, at least in the short term, if not in the long term. And I worry it means it's going to be much harder for FBI agents who knock on the door and say, I'd like to interview you about a crime I'm investigating. Who's going to answer the door and say, sure, I trust you, I'll talk to you. Or if you're a juror and you're sitting in the courtroom and an FBI agent gets on the stand and testifies about something they did or an interview they conducted, is the jury going to be more skeptical of them because they're going to say, oh, you're just one more political animal. I know what this is all about. This is all about politics. And I worry that the long-term consequence of that is that the public will be less safe because our law enforcement agencies and prosecutors will not be able to do their jobs in the nonpartisan way they have always been meant to do it.
You've already exhibited that you are the author of this incredibly important book about disinformation, because you've just been talking about getting away from facts and getting caught in partisan perceptual divisions and so forth. Attack from Within, published last year, out this week in paperback, is a really important study, and your subtitle is How Disinformation is Sabotaging America. Could you elaborate?
Yeah, we live in interesting times, don't we? We have access to more information than ever before, but I feel like in some ways we are less informed than we've ever been. And different segments of society have different sets of facts that they believe are operating. It is my thesis that there are people who deliberately use disinformation as a wedge to divide us to advance their political agenda. And their political agenda really is just power, getting ahead so that we can decide the rules of society. And so we have, I think, a president who deliberately engages in disinformation. I mean, my gosh, just look at his social media feed, if you can stand it, on the ironically named Truth Social, talking about, about things in society. Just one example, I saw today, this new travel ban that is put in place, and on the list is Haiti. And of course, Haiti is the origin country of the immigrants that he accused during a national televised debate were eating cats and dogs in Springfield, Ohio, right? I mean, it's a perfect example of how people are using disinformation to advance an agenda to the detriment of American society. We should have debate about immigration. It's a serious issue. We should have debate about whether we should allow people into our country from various countries around the world. All of that is valid. But when you promote this false claim that people from Haiti in a particular community are kidnapping, stealing our beloved pets, and then eating them, what does that suggest? That these people are animals, that they're barbarians, that they're less than human, that they're not like us, that they are other, and that they're dangerous, that they're changing our society, and your pets aren't even safe in your own community. It's an effort to turn people against a class of immigrants through false claims and to evoke an emotional response. And why? Because he wants to win an election, right? People will naturally be fearful of that, and it will turn some people off. There are other people who will take the bait and engage in that, and the more people are talking about that topic, the more he is winning. I think it is a very cynical view of America, a very cynical view of democracy. Our founding fathers said that an informed electorate is essential to democracy. And so I think when we don't have accurate information, when people are being fooled by these false claims or choosing to lean into these false claims just because it advances the interests of their political tribe, we are undermining the strength of democracy. We should have the courage to admit real facts and debate real facts, even when those facts might be against our political interest, because that's what gets us to the best solution for the most people. And so I really hope that whether you read my book or you learn more about disinformation elsewhere, we need to learn the tactics, we need to build good media literacy, to build resilience against these things, and we need to have the courage to tackle real problems, even when the facts might go against our own political interests.
We have time for a short Q&A, like probably 2, maybe 3 questions by short. So I will see if anybody has any questions. Yes?
How do you deal with making money off of disinformation?
The question is, how do you deal with making money off disinformation?
Our news media does that.
It's lucrative.
Entertainment.
Yeah. So the question is, what do we do when people can make a lot of money by trafficking in disinformation? I think it is a challenge. We live in a capitalist society, and I think the Fox News experience is very illustrative of that. When they reported that Donald Trump had lost the 2020 election, they saw their viewership go down. People didn't want to hear the news that they didn't like, and so they realized that to gain viewership, they needed to tell viewers what they wanted to hear, so they began trafficking in this idea of a stolen election, right? The Dominion voting machines. And ultimately, Dominion prevailed in a lawsuit, a settlement for $785 million or something like that. But we saw the ugly way the sausage gets made in that litigation, right? We saw the text messages and the depositions and all of those things where the hosts, like Sean Hannity and the executives, all said, oh, we didn't believe it for a minute, but we knew it was good for ratings to be able to share this sort of news, so we gave it a lot of airtime. And then even after they paid that settlement, I would have thought, well, they've learned their lesson now. Like a week later, they're calling Joe Biden, would-be dictator wants to jail his rival or something like that. They're back at it. So you're absolutely right that I think there is money to be made, whether it is, Fox News or people who are, InfoWars, like Alex Jones. Alex Jones, ended up having to pay a number of settlements to the Sandy Hook family for pushing claims that Sandy Hook was a false flag and the parents were all actors and all of these kinds of things. He paid tens of millions of dollars. So you wonder, why does he do it? We learned in that lawsuit that his InfoWars website, which sold like all kinds of like survivalist gear, Kevlar vests and rations and things like that, he made tens of millions of dollars a year off of that. So how do you stop something like that when it is so profitable? I don't know that there's any one solution to it, but we do have defamation laws. I think one of the concerns are that it's difficult to prevail in a defamation lawsuit. And we have a First Amendment, which really gives a lot of protection to people to say things against public figures and public officials. As long as the gist is true and you don't have actual malice, you can kind of get away with some of those things. But I think the Dominion case is a good reminder that there is some check on patently false information. And the two poll workers in Georgia who were able to successfully sue Rudy Giuliani, I think is one more reminder of the importance of defamation laws. But no doubt people have found cracks in our society. The unregulated nature of social media is another one where it's very difficult for people to even identify who the false claimant is there. So I think that's one of the reasons that disinformation is so pervasive in our society on the supply side. But I think we can do some things on the demand side by educating ourselves so that we are less likely to be manipulated by those false claims.
Other questions? Marion? Yeah. Marion?
What are your thoughts about Miles Taylor's formal complaint against Donald Trump, challenging whether or not his charges violate constitutional law? I mean, is there anything left in the Inspector's General office?
Yeah, so the question is whether, my views on what's going on with Miles Taylor and his complaint against the Trump administration. So Miles Taylor, you may know, was a White House official during the first administration. He wrote this op-ed in the New York Times anonymously, saying, I'm part of the deep state on the inside, and I'm preventing Trump from fulfilling his worst instincts. And there are more of us, and you're welcome. Like we hide memos, and we're thwarting him from some of the really awful, lawless things that he wants to do. And then he wrote a book about that. And early on in his second term, President Trump issued an executive order specifically naming Miles Taylor and directing investigators, the Attorney General, to investigate him for any crimes he may have committed, including the disclosure of classified information. That, to me, is exactly what Robert Jackson was talking about in that speech, where he says, you don't choose people to go after, you choose crimes based on the evidence, and then you see if there is anybody who committed that crime that you ought to charge. Now, I don't know that he is going to prevail, because I think that although it is a norm and a best practice to choose your crimes and not your people, there's not really a law that constrains the president's authority to direct his attorney general to conduct investigations, just as he's doing with Chris Krebs, who is his cybersecurity chief, who said it was the most secure election in American history. That was his sin. And now Joe Biden accusing him of using an auto pen to sign pardons and questioning the validity of those things. I think those are more political gimmicks than anything. I also think it is an effort to scare people. If you are, thinking about being disloyal the way Miles Taylor was or the way Chris Krebs was, there will be repercussions. And my guess is that Miles Taylor, I think I've read that he has been swatted because his name is out there. I'm sure he gets threats and harassment from supporters of President Trump. And so I think he is more of a cautionary tale. And so other people currently in the administration will look and say, oh, I don't want that to happen to me. I better mind my own business here and remain loyal to this president. So I don't know that it's going to go anywhere legally, but I suppose it is an effort to fight back rather than to cower and to say that I'm not going to accept this fate. So I admire him for standing up, because I'm sure it just reminds people of who he is and that he's out there. So, but I admire people who have the courage to stand up to someone who tries to abuse his power in that way.
Unfortunately, so I'm going to suggest for those of you who still have questions and you have purchased a book, I'll put that little plug in, perhaps we can use some of the signing time for you to ask some of your questions, because we promised this would be an hour and we are just a wee bit over. So thank you all for joining us today for the Department of Justice Then and Now. I'll make a plug for the Jackson Center as well. If you're interested in our future events and programs, and you all should be interested in our future programs and events, please go to our website, roberthjackson.org/events, for more information on those. And we look forward to seeing you again soon. So again, thank you all very much for being here with us. And would you please give Professors McQuade and Barrett another round of applause?
Hey, great job. Thank you. It's smooth. I like that.